you have any colleague, or if you know any colleagues who have not joined yet, you just text them to do so. Yeah. We don't have so much time today, so we just proceed. Now, when we talk about, as I said last week, when we talk of matters that do not require proof, we are basically talking about the fact that as an individual, or as a plaintiff, or as a defendant, as a party in a matter, you have a certain burden which is required by law for you to discharge, which is the burden of establishing a requisite degree of belief in your case or in your matter. As a matter of fact, it is for you to get judicial decision made in your favor, you need to be able to establish this requisite degree or to adduce sufficient evidence to convince the trial of fact that you have a case for which the trial of fact can now hold in your favor or grant the reliefs that you seek. However, under some circumstances, the law of evidence states that there are some matters that do not require proof. Already, to define proof, we can look at the case of Major Labi versus Labi. And this is one of the cases that is not so much about the fact, but so much about the principle that it gives. And in Major Labi versus Labi, it was held that proof in law is the establishment of fact by proper legal means. In other words, the establishment of an averment by admissible evidence. That means that you need to establish some facts, or you need to substantiate your case by adducing sufficient evidence that backs the things that you're seeing. So, for example, someone has accused you of stealing, and then you have a defense of alibi. Now, it is your responsibility to be able to establish or substantiate that defense of alibi. How do you do that? You need to, in your filing of your evidence, you need to be able to file and talk about the fact that you were at a particular place. And we are going to look at admissions and presumptions, but I'm giving a background on matters that do not require proof. And I'm stating that in talking about proof, proof is basically you establishing your case or substantiating your case by proper legal means. So if we talk about the fact that some matters do not require proof, then we are saying that that burden of proving your case is dispensed with. And there are exceptions to the rule that you need to prove your case. These exceptions are considered in judicial notice, and we looked at judicial notice, where a judge can exercise the discretion when a matter is notorious, or the sources from which he is relying on are unimpeachable, for which that discretion can be exercised for you to dispense with proving that fact. For example, the capital of Ghana is Accra. If in your case, you are establishing the fact that, yes, the capital of Ghana, which is Accra, the court will ordinarily not expect you to, because the judge can take judicial notice that, in his discretion, he can admit, and we can all agree, because the notorious fact the capital of Ghana is Accra is also a notorious fact from unimpeachable source. Any source at all that you pick, which has the capital of Ghana, it will point to Accra. If it is Ghana we are talking about, and not the Gold Coast or Ivory Coast or any other coast. If it is Ghana that we are talking about, then the capital surely will be Accra. So those are unimpeachable sources. Now, we looked at that last week, and we looked at the extent to which the application of judicial review goes to. Today, we are going to take our time and look at the two other. Let me mute everybody. So we are going to take our time and look at the two other matters that do not require proof. And one of those is admissions, and the other is presumptions. We are going to start by looking at admissions. What are admissions? In law, what do we call admissions? Now, if you use Justice Brobe's book, that's the Essentials of Ghana Law of Evidence. It explains admission to mean the facts or issue which has been conceded and is no longer in contention. All it's trying to say is that in admission, you admit. And I always tell you that in trying to understand legal principles, sometimes they really have the ordinary meaning. Admission means a party admits a piece of evidence, so it no more is in contention. So, for example, if in the same idea of stealing, someone admits that, yes, I was in, what's it called, Legon at the time it was stolen. When it comes to where he was at the time of the theft, the accused person has already admitted he was there at Legon in one way or the other, a formal admission. So that matter is not in contention. So, for example, let's look at the element of stealing. One of the elements of stealing is that you dishonestly misappropriated something, a subject matter that did not belong to you without the consent of its owner, in a way of depriving its owner of having the subject matter. So if, for example, you agree that, yes, I took the person's money of about this amount, then you have admitted for which reason that person, the law dispenses with the other party, proving that you took the money. Maybe after admitting that you took the money, which is a formal admission, you have a certain that, oh, you took the money because of A or B. But that particular element of you appropriating the money, you have already admitted. So appropriation is not in contention. However, if you come to dishonest, that person has to prove that, yes, you've admitted to taking the money, but that taking of the money was dishonestly done. Then the person will have to establish those things. So when it comes to form admissions, what you are saying is that a party, right, has already conceded, a party has already admitted, a party has already accepted a certain fact, for which reason the court does not need that particular fact to be basically explained, or doesn't expect that evidence is given to substantiate that fact. So, as explained in Justice Brobe's book, admission means the fact or issue which has been conceded and is no longer in contention. So we can work with that definition of admission. Now, even though admission is a voluntary acknowledgement of the existence of a fact relevant to your adversary's case, it means that the fact or issue is no longer in contention. So admission is one of the categories of matters which require no proof. I've already stated in the introduction. So by nature, most admissions can either be inside court or outside the court. But technically, most of them are made outside the court. And which amounts to, and if you know that if a statement is made outside of court, it amounts to hearsay evidence. Now you'd realize that then admission becomes one of the exceptions to hearsay evidence if those admissions are made outside of court. Because outside of court statements are usually hearsay, and we will come to look at hearsay evidence broadly. What hearsay evidence are broadly. But then admissions form one of the prime exceptions to hearsay evidence. And you see hearsay evidence in section 118 of NRCD 323. And admissions can be found in section 119, which obviously talks about the exceptions to hearsay. So 119 of NRCD allows admissibility of admissions as an exception to the hearsay rule. And the hearsay rule is basically the fact that any statement that is made outside of court, technically made outside of court, can be said to be hearsay. Right? Technically. I'm saying technically made because when we get to hearsay, you synthesize a little further to understand the expansive understanding of the law of what hearsay is. But today, we are sticking to admission, and we are stating that admission to start with, is one of the exceptions to hearsay. Now, if you look at the section 119 I'm talking about, it gives us some category of matters that fall within the remit or understanding of admissions, which is, if you read 119, it states that evidence of hearsay statements is not made inadmissible. And the Evidence Act likes to use reverse inverse. So it's not made inadmissible, not in, out. So it's made admissible, right? Evidence of hearsay statement is not made inadmissible. That means that it's made admissible by section, or is not made inadmissible by section 11 if the statement is offered against a party. And so hearsay admissions are an exception to hearsay. And admissions are made admissible if they are offered against the party and the declarant is a party to the action, either in his personal capacity or presumptive capacity. That is, if someone who is a party to an action makes a statement which is in clear relation to the matter, even if that statement is made out of court, that statement is deemed an admission. For which reason? Because he, in his personal capacity or representative capacity, is a party to the action. The court, whatever he has admitted out of court, the court will dispense with the burden of the adversary of proving that particular element of the offense or crime or of the case. B, the declarant was an agent or an employee of the party against whom it was offered, and the statement concerns a matter within the scope of the declarant's agency or employment and was made before the termination of the agency or employment. So, for example, we are stating that company A has gone to, has done something, has stolen money, has gone, put a foot wrong, blah, blah, blah. And an agent of the company has made an admission that I am the CEO of the company. And in my capacity as CEO, I did A, B, C, or D. Or for example, I'm the campaign manager of ABC, and I agree that we made a ploy to do A, B, C. Once the person is an agent of the party, that piece of evidence, even though might be hearsay, technically, it constitutes an admission for which the court is going to consider and dispense with the burden of the other party of proving that particular admission that has been made. Because admission is an exception to hearsay rule. The other one is that the declarant made the statement while participating in the conspiracy. And conspiracy has been defined in Act 29, which has to do with when there's a meeting of mind to commit a certain crime. So there's an agreement, a consensus to commit a certain crime. Because we all sat in the same place and agreed and came to a consensus, if I go and say that we agreed we are going to stay, and we all agreed before we left. Since I was part of the conspiracy, like the theorist, you simply realize that then I have the capacity to admit to a crime for which, when the other parties who were part of the conspiracy are put before the court, that particular fact has been admitted by the other conspirators or by a conspirator, for which reason they can dispense with the burden of proving it because they were all there when the conspiracy was made. The party D, the party against whom it is offered, has manifested his adoption of his belief in the truth of the statement. The party against whom it is offered has manifested his adoption of his belief in the truth of the statement. That means that the party who they are making that statement against has, like, if I say appears, maybe it might be a word that might not really sink in, but has in his actions or his body language or the fact that he didn't object to the statement being made by the accused person, informally, it can be said to be an admission. And we look at informal admissions, where impliedly you admit. So, for example, in someone's pleading, he makes a pleading that's blah, blah, blah. In your statement of defense or in your reply, you did not make a counter plead or you did not make a counter argument to the plea that has been, it would have been deemed to be an admission. That somewhat is a formal admission. But in court, you are being accused of doing one thing. You don't object. You don't have anything to say about it. Your demeanor, your failure to object means that, oh, then you've admitted that you did that. Good. The next one is the party against whom it is offered had authorized the declarant to make a statement concerning the subject matter of the statement. So your witness, or you have authorized someone to come in, or in an affidavit in support of a certain thing, you've authorized someone to render an affidavit and you've tendered it in. And that affidavit or the witness statement that you are tendering in basically has an admission of you doing one thing or the other, which has been alleged by the other party. It would be seen as an admission. So realize that when it comes to admission, what I need to get today, even before we get to hearsay, is that admission is one of the legs of the matters that do not require proof. And also, admission is an exception to the hearsay rule. Let's get these two things. Admission, if you admit it, you dispense, the other party is, it's not, what's it called, mandated, or the court does not, there's no pressure to come and prove because he has already admitted it. It's as simple as that. So that is how we can look at admissions. Now, when parties make claims in a case based on alleged facts, the opposing party may either deny or admit those facts. So realize that admissions can be when a party, as we've stated, an opposing party makes a fact. You must deny that fact. Your failure to deny in itself is you admitting to it, because that matter must be denied. So then it becomes a matter in contention for which that party has to prove. Your failure to deny a pleading which is not in your favor is an admission of that pleading. So the whole line that save us herein, it is you making a traverse. And that general traverse is basically to generally not admit anything that you are saying. However, from the case law that we've read in civil procedure, your failure to personally and particularly traverse or deny the particular facts that are being raised by your adversary is you informally or formally even admitting to those things. So admissions are quite technical. And as a lawyer who is representing someone and replying or making a statement of defense, you need to understand that even if you don't state it verbatim, your actions can be seen as you admitting. And is going to bring us to the two legs of admission. We have one formal admission and an informal admission. Now, a formal admission, an admission is said to be formal when it is contained in pleadings of the opponent. Thus, when opponents voluntarily accept the truth and authenticity of facts averred by the adversary. So a formal admission may occur during cross-examination. So cross-examination, you ask, you stated in your evidence in chief that on the day of the offense, you were present. Not so. Yes, my lord, I was present. You stated, then again, that you were at the scene when the particular crime happened. Not so. Yes, I was at the scene. The knife that was found at the scene is the same knife that was found in your house. Yes, it's the same knife. All those things you are doing is admitting. So even though admission may look very abstract, it's things that happen in court every day. And you also state that you used that knife to stab the deceased person on the day of the offense. My lord, I did not do it. Now that is a denial. But if you state that, my lord, the knife is mine, and you explain, answer the question, yes, I did, you've admitted. That is when the lawyer will go like, my lord, I have no further questions. I rest my case, because you have made admissions, which the judge is going to rely on in his judgment. That during cross-examination, the accused person admitted that he was at the place or at the where the offense happened. He admitted to being the owner of the knife. He admitted to using the knife. He admitted to matter has ended. The case has ended. So admission is a very practical aspect of a litigation process, whether civil or what's it called, criminal. Now, if you look at the other leg of admission, which is the informal leg of admission. Now, informal admissions are presumptive in nature. If we say presumptive, that means the court has to make a necessary inference or a necessary inference from the conduct, incident, and nature of the trial or proceeding. So, for example, if you look at informal, or as a matter of fact, if you look at informal admissions, we have three types. It can either be implied, incidental, or adoptive. It's adoptive when the admissions or adoptive admissions are actions by a party that indicate approval of a statement made by another, and therefore accepting that the statement is true. Adoptive admission means that you adopt the statement of your opponent. You adopt the statement of your opponent. So, for example, if your opponent states that you did A, B, C, and D, like, yes, my lord, I did A, B, C, and D, but you have adopted that statement. And now that statement has become your own. So your opponents go like, my lord, the accused is saying that he did this, that. And like, yes, but no, you have stated that you did this. You've adopted that statement that the adversary is using. Okay, that's the first one. The second one is implied admission. An implied admission is an admission that can be reasonably inferred from the act or statement of the party, or from the party's failure to perform an act or make a statement. So on the day of the offense, you were in the house, yes. You said you just came and met the deceased person on the floor, yes. Did you call the police? No. You picked the body, yes, and went to bury the body, yes. Why did you bury the body? Because I met the body there. It can be reasonably inferred that if anybody came to meet a body lying almost lifeless, the person will panic and try and seek for help. The fact that you were going to bury the body, it can be reasonably inferred that, any reasonable person listening to you saying this thing can infer that you did it. So that's an inference. That's a reasonable inference. And maybe my example might be extreme, but I just want to get the fact that it can be implied from a certain statement that you made, that this is what it is. And that is also another form of admission. Now, incidental and adoptive admissions are sometimes seen as one in the same thing, because incidental basically can be adoptive. So let's not try and do that. So you can just look at the informal as you either is implied or is adoptive. You adopt someone's statement or it's implied. And it is also the implied is also seen as a tacit admission. But also to look further at admissions, you'd realize that if you look at section 19A, it points us to the fact that formal admissions are binding on parties by whom or on whose behalf they were made. So it is either you, the person, the party to the suit, that is making that particular statement, or your agent or someone who has the capacity to speak on your behalf. So they are considered, these formal admissions in law are considered as conclusive against the person who made them and constitutes a waiver of proof. So if in your pleadings, and that is why pleadings are not child's play. Pleadings basically form there's pleadings before trial because it sets the tone of the things that need to be proved during trial. After pleadings, in your civil procedures, after pleadings, that's when they even do the issues, set down the issues for trial. Because after the pleadings, you realize the issues that are contentious and the issues that are not. If you fail to deny a certain statement that is made in your adversary's pleading, it doesn't become an issue of contention for which it needs to be proved during the trial, for which reason they are not going to even admit of that in the issue set down for trial, because you have either failed to deny or refused to deny, for which is considered an admission or an acceptance of that fact. So it is very important that we look at it like that. If you look at informal admissions, you can also look at section 119B, where it states that it should be noted that informal admissions are where you can see the adoptive one, which is adoptive admission, which is indicative of a party's approval of a statement or action by another, and thereby showing its acceptance or beliefs. We've already spoken about the adoptive one. So you realize that the authority for these type of admissions can necessarily be found in section 119 of the Evidence Act. Now, when it comes to admission, we can look at the case of Bessala, B-E-S-S-A-L-A versus Stern, S-T-E-R-N. So Bessala versus Stern. To try and remember the case, you can just remember Stern, because in this action, it was an action for breach of promise to marry. Now, breach of promise to marry is basically when you promise, a man promises a young lady, makes a serious promise to marry that young lady, but not refuses or does not do so within reasonable time. Now, when this happens, you have breached that promise to marry the person. And that promise should be serious promise made before witnesses. And I mean, there are certain conditions to meet. So it's a thing for the young, nice men who continue promising young ladies to marry their men. Let me not go through that. So in Bisala versus Stern, was an action for breach of promise to marry. The defendant's silence by way of answer to the plaintiff's assertion that he had always promised to marry her and that he didn't keep his word was held as an admission. So the woman puts it to him that, boss, you promised to marry me and you had always promised to marry me. You made this promise in front of so many people. It's not only when you were alone in the room. You promised me. You didn't give me a promise ring. And you told me you're going to marry me. But you failed to keep your promise. And the guy just did, And I caught and I say, hey, instead of you to deny it vehemently with your chest, you just did, and give her a stern look. It constitutes an admission, implied, because you had the chance to deny, and you did not. So the court would only take that misdemeanor as an admission. So you realize that admission is a very technical thing in, proceedings, and it should be taken as such. Now, if you look at the case also of Sam Okujoto Ablakwa and another versus Jacob Bichibilanti and another, it was held that where a party is admitted, proof is dispensed with. So where a matter is admitted, proof is dispensed with. And it is in this case of Jake and Okujoto. I think Okujoto has started his usual work as someone who talks out or tries to prosecute people who do wrong or corrupt deeds. So this was in Kufuor's time where Kufuor had compulsorily acquired some state property and was in, state housing properties where I think there were bungalows. There was an apartment or so. And then the apartment ended up being sold to Jake Obechebi, Lantin. Now, Kujato said, lie. People want to steal the property because they didn't purchase it for any good amount of money. So he went to court. And then in that case, they did a lot of putting to, but then most of them were not denied. So they went into it as admissions. So the court had quite a lot to say about admissions. Now, when parties in their pleadings admit certain facts, which I've already stated, or where they fail to deny certain facts, which I've already stated in pleadings by the opposing party, the requirement of proof of those facts is dispensed with. So please, when you're drafting your pleadings, remember, especially your statements of defense and replies, remember that it is imperative that certain facts which goes against your client, you deny them. Forget the general travels. That one there is about, you have to put it in your head, chew and pour, go and put it down. But you need to take the various averments that have been made one after the other and deny them with your full chest. It's very important that you do that. Now, in criminal actions, formal admissions may comprise of plea of guilt in the criminal actions. Do you plead guilty or not guilty? My lord, I'm guilty. Admission. When you accept the guilt, it's cool. It's okay. We move on. It's not a big deal. The judge will just look at the fact that, you didn't waste the time of the court. You're candid, frank, sincere. Because of that, you have a reduced punishment. It will mitigate the punishment that will be given to you. So that brings us to the end of admission. Admission is not a very broad thing, but you can be tested on it. And possibly, after we do today and tomorrow, the next meeting, we will look at some questions. So I don't know if we'll meet on Wednesday, but if possibly we meet tomorrow, which is likely, and we do whatever we have to do. The next time we look at questions based on what we've done. And then hopefully we have a question on admission. I'll make sure of that. So the next thing we are going to look at is presumption. What is presumption? We're going to look at presumption. What's presumption? Presumption was one of my favorite topics. Is Stella on the line? Yes, Fatah, your hand is up.
Hi, Senior. Is it possible that we can look at the questions tomorrow instead? Because we have Sybil on Wednesday.
Okay. Okay.
I'll
look for the question.
So, Fatah, Sybil is tomorrow. Sybil is tomorrow.
Sybil is tomorrow.
Yes.
What has the time been changed?
Yes, it's been changed. He said he's traveling on Wednesday evening, so we cannot meet on Wednesday. We'll meet tomorrow.
Oh, okay, cool. Then we can do the questions on Wednesday then. All right.
Okay.
Thank you.
All right. You're welcome. Okay. Thank you. So we'll meet. We'll meet on Wednesday for the questions, definitely. So you are going to look at presumptions. What are presumptions? What do they stand for in law? Presumption is a very broad topic, and it's very examinable. More often than not, you get questions on presumptions. And presumptions, my opinion, is quite technical. So I can only advise that we pay attention to it and get the very idea of presumptions. When we talk about presumptions, it also forms one of the matters that do not require proof in law. And then if we say one of the matters that do not require proof, I think I've gone over it. I've said it over and over again. But basically, The rules of presumptions are found in part 3 of the Evidence Act, particularly section 18(1). It goes on to look at certain aspects of presumptions, which we are going to look at today. We are going to take our time to look at presumptions today. Now, if you look at section 18(1), it defines presumption to mean an assumption of fact, which the law requires to be made from another fact or group of facts found or otherwise established in an action. So presumption is an assumption. That assumption can only be made from another fact or group of facts, which the court thinks is okay. So once A is valid, then B is valid, is how presumption works. So if you look at presumptions, which is 18(2), it also talks about an inference. It also defines what an inference is. And this inference that it defines has, for me personally, has a very good link to understanding what circumstantial evidence is. The definition of inference that it gives is a deduction of facts that may logically and reasonably be drawn from another fact or group of facts found or otherwise established in the action. Now, what I'm saying is that when it comes to a presumption, it is an assumption of facts, which the law, it is not the judge that is using his discretion because it's notorious, which is judicial notice. However, it's an assumption that the law. So for us to state that this is a presumption, it is the law that is stating that if A and B is so, then C is so. For example, if a man and woman are married, the child from the marriage can be said to be the child of the man. If a man is married to a woman and the woman takes seed, that child, that seed of the marriage can be presumed in law. That presumption can either be irrebuttable or rebuttable. And this particular one is rebuttable. It can be rebutted. But so far as the law is concerned, the law assumes that then the child belongs to the man. So that's how presumptions work. Presumptions are assumptions that are made by law. So for something to be said to be a presumption, a law, a statute must state that if this is this, then we are assuming that then it is this. And we are going to look at the various assumptions that the law makes. But to understand presumption, you are realizing that we are looking at two aspects: inferences and assumptions. Now, if you look at the assumptions bit, as I said, it's more often than not relates to circumstantial evidence, because with circumstantial evidence is when we are making deductions, logical and reasonable deductions, which are drawn from facts or group of facts to come to an irrebuttable conclusion. So I feel when it comes to inferences, they are more leaning towards explaining what circumstantial evidence is. And realize when it comes to circumstantial evidence, it seems not to have a provision in the Evidence Act. I beg, that's a personal opinion though. You might necessarily not find it in the books that you read, but in my opinion, this is where circumstantial evidence, the very idea of an evidence being circumstantial evidence, gains a statutory blessing from. But presumptions are more of assumptions that the law requires to be made. So when it comes to presumptions, it's an assumption that a fact exists based on known or proven existence of a basic fact. So presumption is a basic fact. If that basic fact exists, then the law requires that we assume that then this is the situation. This is how presumptions work. If this basic fact is established, then it can be assumed that this is what it is, right? So when it comes to presumptions, it is illustrated by if Kofi proves that fact A, which is the primary or the basic fact, exists, then the court will be entitled to conclude. The court is enjoined to conclude, or the law requires the court to conclude that fact B exists or is presumed. So for you to have a presumption, there needs to be a basic fact which is proved and established, upon which we are going to assume the existence of the presumed fact. What am I saying? I'm saying that if we can prove a basic fact that A and B were married at the time the child was born, we prove that indeed they were married. Yes, they were. I've proven that they were. Then the law allows us to assume that the child that was born. So for you to be able to make that presumption, you need to be able to establish or prove a basic fact or a primary fact. It is on that basis that the law takes effect. So the court may only rely on presumption to pronounce on an issue notwithstanding the fact, or the law can only make a presumption when a basic fact for which that presumption stands has been established. Without it, you cannot make the necessary presumption. So presumptions basically help the court by allocating the burden of proof in relation to an issue to a party. Now, that burden is only for the party to prove a basic fact. Then the law then allows that you dispense with proving that secondary fact. So in essence, the effect of presumption is that a party in whose favor the fact is presumed is relieved of the initial burden of proof of that secondary fact. So the court may presume that the existence of the fact is in favor and may act upon it unless the contrary is shown. And the contrary is shown if the presumption is a rebuttable presumption. If the presumption is a rebuttable presumption. That brings us to the fact that we have two classifications of presumptions: rebuttable and irrebuttable presumptions. So the distinction that I need you to get is between presumption and inference. Although sometimes they are used interchangeably, they are not the same thing. If you see presumption, that means that the law, as there's an assumption that the law requires to be made. Presumption, it is the law that requires it to be made. Please keep this definition in your head. Don't let it leave your head. It is an assumption of fact that the law requires to be made from another fact or group of facts. What it's saying is that it's an assumption of fact that the law requires to be made from a basic fact or a group of facts. So unless that basic fact or group of facts is established, the law will not kick in, or the assumption that the law requires to be made will not be made. However, if you look at an inference, it is not an assumption the law requires to make. It is just deductions of facts which may be logical and reasonable, or it may be logically and reasonably drawn from the facts. And as I said, I strongly believe it has a lot to do with circumstantial evidence. So an inference is never mandatory, but it's a choice based on logical and reasonable conclusions or deductions being drawn. However, presumptions is a must. Once the basic fact checks, the secondary fact is presumed by law. Please get this basic understanding and you're good. Okay. Now, you need to realize that even though the law requires, if the presumption is an irrebuttable presumption, then it cannot be questioned. Technically, it can under certain circumstances, but generally, it cannot be questioned. However, if it's a rebuttable fact, that means that it can be rebutted. If it can be proved that, well, yes, there are some intervening circumstances which does not make the position that the law is assuming us to take to be right, then the other party can bring that, well, even though the law requires that, we assume and dispense with the burden of the other party to prove. this and this and this is my reason why the party must prove, or I object to that presumption. And we are going to look at that shortly. A presumption is a conclusion that a judge or a jury must make. You need to understand that when it comes to presumption, it is mandatory. Once the basic facts or primary fact checks, the secondary facts must be presumed. Okay. Now, we've established that if we look at the distinguishing factors between presumptions and the likes, it'll be a long night. Let's go to conclusive, the distinction between conclusive and rebuttable presumption. And that can be found in section 18.3. We've looked at 18.1, defines presumption. 18.2 defines inference. 18.3 distinguishes between conclusive and rebuttable presumptions. So it's either irrebuttable or conclusive or rebuttable. Okay. And we will look at that also. If you look at 19, it provides the assistance in determining whether a provision in any enactment amounts to a rebuttable or conclusive, according to where an enactment provides that a fact or group of facts is only prima facie evidence or another fact. The enactment creates a rebuttable presumption. So if an enactment says that it's only a prima facie evidence or another fact, then what it's creating is creating a rebuttable presumption that even though as a prima facie fact, under the second, you can rebut or you can give evidence to show. So a rebuttable presumption is a presumption that is assumed true until or unless a person proves otherwise. So unless you can come and prove to me that the man and the woman were not married, or you can come and prove to me that even though Kwame and Amma were married, there's a DNA test that proves that even though they were married, the child does not belong to Kwame. And then we go on to prove that at the time Amma and Kwame there was an intervening event or an intervening individual, then you've rebutted that basic principle. The basic principle is that you are either proven that they were not married or there was an extramarital activity that caused it, which can be proved. Good. So basically, a rebuttable presumption is a presumption that is assumed true until or unless the person proves otherwise. So in such a presumption, or once such presumption is relied on by one party, the other party is normally allowed to offer evidence to disprove or rebut that presumption. So in criminal cases, the prosecution can rebut a presumption of innocence with evidence proving beyond reasonable doubt the defendant is guilty. So you can always look at it from that point of view. Now, there's a presumption in law that everyone is innocent unless proven guilty. In a criminal trial, the burden is beyond a reasonable doubt. Now, that presumption of innocence unless proven, that means that it's a rebuttable presumption. If it is proven, then that presumption will no longer stand. It's a rebuttable presumption. That presumption is as of right. The accused person is innocent unless it can be proven guilty. What is it? Once the person is an accused person, basic facts established, he is accused, the law requires that that person is deemed innocent unless it can be proven otherwise. Right? So you realize that that's a rebuttable presumption. In contrast, a conclusive presumption cannot be refuted in any case. It is conclusive, incontrovertible, and does not admit evidence to disprove it. They must be accepted to be true without the opportunity of rebuttal. So, for example, it is an irrebuttable presumption that children under the age of 12 are incapable of forming intent. Thus, children under the age of 12 cannot be criminally prosecuted. It's a conclusive presumption. They cannot be criminally prosecuted. So you realize that some presumptions can be seen as conclusive. Others can be seen as rebuttable. Now, if you look at rebuttable conclusions, if you look at conclusive presumptions, it cannot be controverted. If you look at, for example, section 24 and other sections along those lines, other sections, you realize that a conclusive presumption can be said to be a presumption which, once admitted, cannot be challenged. Now, what are the effects of a conclusive presumption? Now, the effects of the presumption is that it concludes the matter as presumed by the court or tribunal. Therefore, if you look at section 25 of NRCD 323, the facts recited in a written document are conclusively presumed to be true as between the parties to the instrument or their successors. And we particularly look at some fact pattern where this might come up, that if there's a written document properly signed and executed, then it is deemed to be conclusive and true, and it affects that individual and their successors. Now, similarly, when a party, by his own statement, acts or omission, intentionally and deliberately causes or permitted another person to believe a thing to be true and to act upon that such belief, the truth of that thing shall be conclusively presumed against that party or its successors in interest in any proceeding between that party or its successors in interest, such as relying persons of the successors or interest. So if you look at section 26 of NRC, you realize that one is estopped by his own statements and conduct. So if you look at two of those ones, if you start from section 24 of NRCD, it defines what conclusive presumptions are. Section 25, it deals with the first presumption, conclusive presumption, which is that a written document is seen as conclusive. If you look at the next one, which is 26, is looked at is estoppel by one statement and conduct. You are stopped from not relying on it. So if you look at a tenant is estopped from denying the title of his landlord as a title of his landlord at the time of commencement of the landlord tenancy in relation to the conclusive presumption to be valid. So that's commencement in drafting, that the house belongs to the landlord. You've admitted, like it is there. You are stopped from denying his title. And you realize that in law, if you deny that title, if you question the title of the owner, then basically you lose your interest, because the law presumes that if you basically conduct yourself in a certain way where you agree or state anywhere that this car belongs to A, state signed, if it's a formal document, and even the 25 acts more, because then it becomes a formally written document, which is conclusive. And so you should look at presumption from that point of view. So if you look at presumption, you realize that from conclusive presumptions, you realize that from section 24 to 29, there are all sections. So the first one, section 25, deals with facts recited in written instruments presumed to be valid. If you look at section 26, they are stopped by own statements or conduct. If you look at 27, you are stopped, tenant is stopped from denying the title of a landlord. If you look at section 28, you realize that a licensee is stopped to deny the title of the licensor. If you look at section 29, you realize that a bailee is also, or an agent is stopped from denying that there's a bailment or agency or a license that exists between the party. So you should look at these sections and keep them in your mind. A question can come, presumptions. It's a conclusive or irrebuttable presumption. And the caution may relate to 1 or 2 or 3 of these sections: 25, 26, 27, 28, 29. However, conclusive presumption is defined in 24. Okay. Do we have questions? I think that I've gone along or without allowing you to ask questions. For the benefit of those who need more explanation on conclusive presumptions, you realize that in the case of the Republic versus National Petroleum Authority, it was indicated that there is a clear difference between estoppel and conclusive presumptions, because there's estoppel in law and there's conclusive presumptions. Even though functionally they have the same legal effect, and that there are two main differences between them. Now, the first difference, as seen in the case of Republic versus National Petroleum Authority, which is, I think it's a 2021 case. You realize that the first difference is that when it comes to procedural, estoppel is procedural in nature, and it must be pleaded before evidence may be adduced to establish. But when it comes to presumptions, it's not pleaded. Why isn't it pleaded? It's not pleaded because it is the statute or the law that makes that assumption. When it comes to estoppel, you are pleading that this party, based on this, is stopped from claiming this particular thing. When it comes to presumption, it's not an issue of pleading. It's an issue of the fact that the law states that once a document is written and executed by two parties, the other party is a written official document, and another party is what's it called? It's presumed to be valid, and the other party cannot be allowed to come and deny it. So it's irrebuttable. You sign it, unless, of course, it's vitiated by fraud or some other events like that. That's why I'm saying that under certain circumstances, even though it's irrebuttable, under some circumstances, they can still be set aside. Now, the second difference is that a person who pleads estoppel is required to adduce evidence to prove sin and could be effectively settled whether it is proved or otherwise. So if one pleads estoppel, you are required to adduce evidence to establish it. But in the case of conclusive presumption, the other party is prevented. It's a matter that does not require proof. So there's basically a distinction between, and these are the two distinctions I can give. The effect of presumption is conclusive, is that it operates almost in the same way as the rule of substantive law. So it's the law that requires that assumption to be made and that assumption to be maintained. So as I said, you can look at 25 to 29, which talks about facts recited in a written statement being presumed to be conclusive. Estoppel by one's own conduct being presumed to be conclusive. Estoppel by a tenant to deny title of a landlord is also presumed to be conclusive, and so on and so forth. Okay. Please, any question? I already told you about the conclusive presumption which has to do with dolly incapax, that if a child is below the age of 12, it is conclusively presumed that he does not have the capacity to form the requisite mens rea to commit a certain offense. So bear that in mind. So on this note, we are done with conclusive presumptions. We come to rebuttable presumptions, and that will be the last thing we look at today. When it comes to rebuttable presumptions, you realize that, as the word suggests, it can be refuted or rebutted. If you look at Section 20 of the Evidence Act, it provides that a rebuttable presumption imposes upon the party against whom it operates the burden of producing evidence and the burden of persuasion as to the non-existence of the presumed fact. So, when it comes to rebuttable evidence, even though the law allows us to make an assumption, the other party against whom, bear in mind, when it comes to rebuttable, it is the party against whom that presumption acts. The presumption affects. The party against whom the presumption affects is the one who is supposed to adduce evidence to rebut that presumption. So it is the presumption. It is a presumption that the court must make unless evidence is adduced to the contrary. With rebuttable presumptions, when the basic fact is provided, the presumed facts must be accepted as proved as well. If the presumed fact or if the basic fact is proved, the presumed fact must be accepted as proved as well. Now, if you look at section 21 of the Evidence Act, in several cases where the standard of proof is on the preponderance of probability, the test in applying rebuttable presumption is an objective one, and the standard required to rebut a presumption is also on the preponderance of probability. So all it's saying is that in a civil case, when the basic fact is met, the law requires that a presumption is to be made. If a party against whom that fact affects wants to rebut that presumption, that party needs to rebut a presumption on the standard of preponderance of probability. That means the court needs to look at it that from a reasonable point and see if on the preponderance of probability that fact can be rebutted. If you also look at section 22, it deals with rebuttable presumptions regarding criminal cases, and it states that a presumption operates against an accused to a fact which is essential to the guilt only if the existence of the basic facts that gives rise to the presumed fact are found or otherwise established beyond a reasonable doubt. And in the case of rebuttable presumptions, what these two sections, 21 and 22, seeks to do is seeks to establish that when it comes to rebuttable presumptions in civil matters, the party against whom that presumption acts has the opportunity to rebut the presumption. And if it's a civil matter, according to section 21, it's supposed to be rebutted on the preponderance of probability, which is definitely the standard when it comes to civil issues. However, section 22 states that if it's a criminal matter, and then the law requires a certain presumption to be made, it needs to be rebutted beyond reasonable doubt. That means the standard that is required in criminal trials or criminal cases is maintained when it's being rebutted. Now, if you look at section 23 of the Evidence Act, it highlights the procedure in applying presumptions in jury trials. And accordingly, in criminal matters, the court shall not direct the jury to find a presumed fact against the accused if that fact is essential to the guilt, unless, on all evidence, a reasonable mind could have no reasonable doubt either at the existence of the basic fact that gives rise to it. So then basically, when it comes to judge and jury, the court shall not direct the jury to find a presumed fact against the accused person. Because when it comes to a rebuttable fact, the fact is that it can be rebutted. So if the court directs a jury to take a certain position on a rebuttable presumption, it can go a long way to basically undo justice or to affect the administrative of justice, or it can cause grave miscarriage of justice. So take note. Now we are going to look at the particular provisions that deal with rebuttable presumptions. It literally starts from section 31 to 49, and also section 151 to 162. Please put these blocks in your head. You need it. Section 31 to 49. We are going to look at 151 to 152. I'm going to take my time and go through some, if not all of these. Okay. All right. So if you look at section 31, it deals with marriages which have been celebrated before witnesses. Now, the law states that if a marriage is celebrated before witnesses, it is presumed to be valid. That is, every other thing being equal. You go to the registry or the registrar of marriages, or you go to the court and sign. Witnesses sign. It is presumed that it's a valid marriage unless proven otherwise. This applies to both monogamous, polygamous marriages. If you go and do your traditional wedding or marriage or customary marriage, and then there are witnesses there, it is presumed valid for the fact that people have witnessed and can testify that that said marriage did okay. Now this, and I've already stated, it applies to both monogamous and polygamous marriages. By this provision, when there is evidence of a de facto marriage under the marriage ordinance or the customary law, there is a strong presumption of marriage unless it can be shown. Unless it can be shown evidence can be shown to the contrary, that marriage did not indeed occur. In order for two people to be validly married, it is necessary to fulfill two conditions. Each person must have the capacity to marry. And then they must have gone through the ceremony of marriage, which is the law recognizes. But then the presumption of marriage may be displaced by the evidence to the contrary. And what the section really focuses on is the fact that there are witnesses to the purported marriage. Then it is presumed that that marriage is valid. So the validity of a marriage, presumptively in law, is the presence of witnesses. It can be rebutted that even though there were witnesses, the marriage is not valid for some other reason or the other, for which the party, because the civil matter, has to adduce evidence on the ponderance of probability that that marriage indeed did not occur. The second one is presumption of the legitimacy of a child. And I use as an example, which provides that a child born during the marriage of a man is presumed to be the child of the person who is the husband of the mother at the time of the birth. That is, if you are married to B and B gets pregnant, I beg you, don't go and look for the child's father anyway. You are the one. However, it is not conclusive evidence. You can rebut it. You can adduce evidence in court to prove that that child does not belong to you. And please don't make that mistake and go and misfire when the child belongs to you, and go and try and prove that it doesn't belong to you, or else your life will become miserable. Now, that's just a joke though. Please don't take it seriously. It further provides that a child of a previously married woman born within 300 days after the end of the marriage is still presumed to be the child of that marriage. So bear in mind, in 32, they stated a general presumption. If a child is born to a married woman, is believed to be dead. However, if the marriage even ended, 300 days after the marriage ended, a child is born, it's still presumed that your ex, when you give birth to your child, I broke up with him, I divorced him long time ago. Long time ago, how long? It's 200 days, and you gave birth today. No, the child is his. Because it's doing 300 days. Please remember this rule. You know how they like exceptions. The fact that the basic fact that needs to be proved when it comes to this particular thing is either that the mother was married at the time of conception or at the time of death. And then the law would presume that the woman's husband is the father of the child. If you look at the 300 days, it has been interpreted in the evidence decree, the commentary of the evidence decree, to mean 10 months. But 300 days is 300 days. It's even more circumspect than 3 months. Therefore, a child born 3 months after the resolution of marriage is presumed to be the child of the husband. Essentially, this presumption is to the effect that the husband is a biological father of a child born to his wife during the marriage, and within 9 months after the marriage is ended. And mind you, the law doesn't say anything about if you went to marry the woman and the woman gives birth within, no, it applies when the marriage has ended. Because once you are married to someone, the person gives birth, you are presumed to be the father. Case closed. Now, if you look at the case of R versus Overberry, R versus Overberry, like over and Barry, which is Bury. The mother gave birth, right, 2 months after she had been married for a second time, with her first husband having died 6 months before the marriage. It was held that because the child was conceived approximately 9 months before birth, the presumption which was to be applied was that the father of the child was the man that she was married to at the time of the conception, aka her first husband. So even though the law is not clear as to if you leave someone and at the time of conception, so then the R versus Overberry states that if at the time of if you divorce someone, you marry, like you even remarry, it will be the child of, because the 300 days have not passed, it will be the child of your ex. And that's what R versus Overberry states. Now, the presumption of the legitimacy of a child can be rebutted. And one of my favorite cases when it comes to this is basically the case of Dobia Dagati versus Donipia. In this authority for principle, the presumption of legitimacy of a child. So, if my memory serves me right, it had to do with a woman who had left her husband to go and stay with her boyfriend during the subsistence of the marriage. And that the man was pained and the man died sometime later. Before the man died, he had returned the schnapps and or before the man died, he had gone to complain to the uncle of or the family of the woman that she's being stubborn, obstinate, and not blah blah. So he wanted to end the marriage, and I think the marriage ended. However, when the man died, some months later, the woman gave birth to a child. Now, the family of the man then attempts to take that child because, in their opinion, is a child of the man. And there's some sort of dispute. Now, the disputes that arises between them, there's going to be a termination. However, the law dispenses with the burden of proving because they are saying that if a child is born within the subsistence of the marriage, then that child is the husband's of the woman's child. However, this was different. And I think in this particular case, the 300 rule had not applied. So it was held against the 300 rule. But now the 300 rule now applies. Therefore, even if they are divorced, or even the man is dead, 300 days after his death, if the woman gives birth, is presumed to be the child of the man, the deceased man. There's a theoretical presumption of death, and we move a little fast from there. So the presumption of death has to provide that a person has not been heard from for 7 years, despite diligent efforts to find that person, whether or not within that period, that person is presumed. So whether or not within the period of the 7 years, that person presumed to be dead. So you after 7 years, you go and hide, 7 years not found, we can just do a funeral and then move on in life. The presumption does not apply to a particular time when he died. The presumption is available as a defense to the charge of bigamy. So forgetting the two parts I said, what you should understand is that this is one of the rebuttal presumptions. The rebuttal presumptions is that if you've not been heard from for 7 years, even though we've done diligent search, we can state that you're no more. Now, we also come to simultaneous deaths, which we've seen in, I think, the Wales Act 34, provides a subject to an enactment relating to succession of property, where two or more persons have died in circumstances in which it was uncertain who survived the other, the older is presumed to have predeceased the younger. It is also known as the commemorator's rule, and I believe we all remember. So that's also a presumption that if two people die, the basic fact is that two people have to die simultaneously. And then there should be some subject matter of disposition between them. It will be presumed that the older one predeceased the younger one, or the older one died before the younger one, for which the disposition will be made to the younger one or his family. Now, there is Section 35, which deals with presumption of beneficial title, which is that the owner of a title to property is presumed to be the owner of the full beneficial title. So if one has a legal title in his possession, it is presumed that he's the full beneficial owner, unless proven otherwise. Official duty regularly performed is also a very important one, which is that Section 37. It's presumed that an official duty has been regularly performed. An official duty regularly performed. So you should also look at that. It does not apply to an issue of lawfulness of arrest, but if you look at official duty regularly performed, if the Chief Justice is supposed to empanel, like Kwasi Adam versus at Akufo-Addo and the others, empanel all those line of cases, you realize that the Chief Justice has a duty, and that duty cannot be derogated from, whether or not you cry bias or natural justice. The Chief Justice is performing a particular responsibility, and he must be allowed to do it. It also falls in line with the maxim, equity looks on as done which ought to be done, which is basically that one, which is official duty regularly performed. Now, ordinary consequence 38 deals with ordinary consequence of voluntary action. That is, a person is presumed to be intended or presumed to intend the ordinary consequence of voluntary action, not the ripple effects or anything, the ordinary consequence. So rationale for this provision is that when a man does something consciously and deliberately and not by accident, he'll be deemed to have intended. Like, he definitely intended to do it. He had intention of doing it. This is not applicable in criminal action to establish specific intent. So you can look at that too. You can also look at foreign law, which is Section 40, provides that the law of a foreign country is presumed to be same as the law of Ghana unless it's reverted. Continuation, which is 41, it says that a thing or a state of things which has been shown to be in existence within the period shorter than that within which that thing or state usually ceases to exist is presumed to be still in existence. So this is also about continuation. And we also have 42, which deals with full age and full body, which states that a person is presumed to be of full age and sound body. Now, we also have presumption of ownership, which is rebuttable under Section 48, provides that the things which a person possesses are presumed to be owned by that person. Once you're in possession of something, you're presumed to own it. Partners, landlord, tenants. Section 49 deals with the fact that persons acting as partners, landlord and tenant, and principal and agent are presumed to stand in relationship to one another. So if you're acting as a partner, you're acting as a landlord or a tenant or principal and agent, you are presumed to be standing in a relationship of agency, a relationship of whichever relationship. So you're basically standing or acting in that person's interest. If you look on and go to the Section 1512, realize that 154 talks about all publication acts and acts of state, whether legislative or executive, all fall within the rebuttable, what's it called? You can look at gazettes, which is in 154. You can look at seals. It's presumed once it's gazetted, there's a presumption that then is valid. If it's sealed, there's a presumption of it being valid. For example, a rebuttal presumption include even article of a constitution, which is Article 19.2, which states that on the innocence of an accused person, accordingly, a person charged with an offense shall be presumed to be innocent until proven guilty. And it goes on and on. So this will bring us to an overview of the presumptions, which is rebuttable, irrebuttable presumption. If you have any questions, you can ask. If you can't think of one now, I'm sure at any point in time that you can think up your question. You can always revisit it. The next time that we meet, we will definitely look at some questions just to help us apply what we've learned, to look at the scope of what we've learned, and also to start working on our question answering skills. All right. If anybody has any comments, any questions, I'll listen to it. If not, I believe that we've had a good night. We'll call it a night. Any questions, any comments? All right. Muchas gracias. Enjoy your night.
Grateful, sir.
Welcome, my boss.